Public Interest Law Centre Section 27 says the South African Council of Educators is failing to hold teachers using corporal punishment accountable. Civic groups are challenging what they regard as lenient punishments for teachers found guilty of beating up children in schools. Joining us is Faranaaz Veriava, Head of Education Rights at Section 27. Faranaaz, thank you so much for your time this afternoon. Talk to us firstly about the prevalence of corporal punishment in schools still.
Yes, well, we know it is very prevalent, despite the ban, which happened in 1996, and more than three judgments actually, outlawing corporal punishment in the home, but also in the school. According to the latest General Household Surveys data, 7% of learners in schools complain about corporal punishment. That translates into about 1 million learners. What we've been saying is also that the complaints that we receive at Section 27, these are not complaints, mild complaints of a slap on the wrist or caning with a ruler, but they are often cases of assaults, very serious assaults perpetrated by teachers towards young learners. Not, one of the arguments that are being made on the other side is that schooling communities are becoming more violent with learners being violent towards teachers. Yes, that is true, but the kind of cases that we are asking for different sentencing on are the cases where these are young, vulnerable learners that have been severely assaulted by teachers, as in the case of our two learners in this particular case. So what we are asking for is appropriate sentencing.
And what do you deem appropriate sentencing? Because there are two cases that you are pursuing. One where the teachers were fined 15,000 and 10,000 rand respectively, and a suspended sentence of a 10-year ban, if I'm not mistaken.
Yeah, no, that was not the sentence. So let me say that the South African Council of Educators have something called their sanctions guidelines, mandatory sanctions guidelines. And there are very few standard sentences that they include there. The one is a cautionary warning, the one is a fine, and the other one is being struck from the register of SACE's register of teachers. And in this case, there were different cases. They both received the same sentences, which is a 15,000 fine, suspended to 5,000 in each case. The other one was removal from the role, completely suspended. So they had to pay 5,000 rand and they could go back to the classroom. And these are the kinds of what we are calling cookie cutter sentences that we are seeing across the board where there's a guilty finding. I heard the other day from a journalist that there was a teacher that was found guilty of very serious abuse against a matric learner, and he got the exact same sentence and was promoted to vice principal. So what happened was we took these cases to court on review, our cases, and we asked that the mandatory sanctions guidelines be reviewed, so that, for example, if the particularities of the case necessitate that, for example, the person is suffering maybe a lot of burnout, mental health strain, he can go for anger management classes, get counseling, but that would address the problem to make the teacher to go back safely to the class. In other instances where you can't see any form of rehabilitation and there are serious cases of assault, those are the kinds of cases where you can't have a suspended sentence and send the teacher back into the classroom. The best option there would be to have such a person who's a danger to children not back in the classroom. So what we are asking for is a review, and we are also asking for the remittal of these two teachers back to SACE for her to have their disciplinary hearings reheard. And we've got we've won on the one issue, we haven't won on the second issue. And that is what is going on appeal to the Supreme Court of Appeal.
Well, let me take you to an article published a couple of years ago from the Richmond Secondary School, where management said it was clutching at straws trying to put an end to learners gathering outside school premises to smoke and use drugs. Now, this is a school principal who made this report a few years ago somewhere in KZN. Now, what educators are having to deal with are, in some instances, learners that are high on drugs when they come into class and obviously become extremely unruly. Now, this is obviously not justified, but how prepared or how equipped are educators to deal with errant learners?
Well, that's exactly the case. But I don't think going and beating a whole lot of learners who are high is going to be the solution to the problem.
No, I'm not suggesting that is the solution.
I know you're not.
My question is, how prepared are they to deal with errant learners? Because it's one thing to be equipped with a skill set on educating learners. It's a totally different ballgame if learners are errant, if they are bringing knives into classrooms and all sorts of unruly behavior that one would imagine.
Yes, I don't think they are being properly equipped to deal with overcrowded classrooms, to deal with classrooms where there are a whole lot of other social, economic issues at play, and that is where our policies and programs should be directed to assisting these teachers to manage these classroom situations. The other thing is that in the same way, there should be appropriate procedures to deal with errant teachers, of which there are many, as in a profession that is one of the most noble professions in our society. We should be able to weed out the people that shouldn't be in that profession. On the other hand, where you have difficult students coming into the classroom with knives or high or whatever, there are also processes currently in our Schools Act, in the criminal justice system, and all of that to be able to deal with these things. So if you have a learner in the classroom that's coming in with a knife, then discipline that learner. If the discipline requires a suspension or an expulsion, then that is also something that can be done within the schooling environment. But to say that we need corporal punishment to solve the problem of the broader socio-economic difficulties that we are experiencing in society, I don't think that is a solution. And in fact, research shows that where learners are beaten and experience corporal punishment, they're more likely to be rebellious and difficult than the other way around, which is to get them to behave appropriately.
Now, your engagement with the SA Council of Educators, have you made much progress in that regard, and certainly putting your points across and getting any value from that interaction?
Well, the matter is currently in court, so it will be arbitrated in court. We in the process, when we received their disciplinary committee findings in respect of our two teachers, obviously there was a process where we asked for reasons for the process, and we looked at ways of maybe seeing if we could get alternative sentences in respect of these two teachers. That didn't work, which is why the matter has been taken on review to the High Court, and where we got a partial victory, we are taking the part that we were dissatisfied with to the Supreme Court of Appeal.
Now, finally, speaking of these two teachers, obviously there were a couple of learners that were involved in that particular case. Did they receive any form of counselling?
No, nothing.
And is that something that you've been pushing
nor
for?
Nor were the parents asked how they feel about the sentences. And in terms of the SACE rules for disciplinary procedures, they should have been asked how do they feel about the sentences. They should have been given a hearing themselves around the sentences. They weren't.
Okay, Faranaaz Veriava, Head of Education Rights at Section 27. Appreciate your time this afternoon unpacking that conversation around corporal punishment.